Hello, everyone. Thank you for being patient with us with our delay. But we are here with Boam of the Americans with Disabilities Act, or the ADA. He's our state representative here in Utah.
I represent people in it, and I do a lot of consulting. I'm not sure no one's elected me to this position.
Self-proclaimed.
Self-proclaimed, there we go. I'll take that.
Okay. So he's a really fabulous resource about the ADA and the laws and rights that we have. So I'm going to turn the time over to him so we can really dig into this and run on time. But if you have a question or a scenario that maybe you have dealt with and you're not sure about what exactly your rights were or how that works, please feel free to put those up in the chat, and we will be as interactive as we can. So thanks, Dale.
So the Americans with Disabilities Act, saying what is it? That's kind of like asking someone, where did you go on vacation, and they say Canada. That's a huge country. There's a whole lot there. Here's what a lot of people don't know. The ADA, when you look at it specifically, it's not really just one law. It's kind of like the college dormitory of laws. It's 5 different laws that just happen to be on the same general topic, and they just all got thrown in the same folder together, like roommates in a dorm. It's not because they have anything in common, they're just all going to the same college, so that's how they all got together. If you read Title I, there are 5 sections of the ADA. They're each called titles. If you read Title I, you don't know, you may know everything about employment, how the ADA applies to employment, but Title II is about government services, and there are vast differences between who qualifies, how, if you win, what do you get, what kind of damages you can get. Those are completely different from Title III. The last 2 you'll never use. If you ever want to visit the Library of Congress and want an interpreter, talk to me about Title V. That's about the only time it'll ever come up. You have to know that each one of these sections, each one of these 3 titles that really we'll be focusing on, are very, very different. The only reason they're together is they all talk about people with disabilities. And so generally, in most cases, when we're talking about children, Title I is about employment. And so you talk about high school kids, you're definitely going to be getting into Title I. Title I it applies to businesses, both private businesses and government agencies, and their hiring practices, in hiring someone, in promoting them, in training them, anything that has to do with a business. There are a couple of rules though. Number 1, in order for a business to have to follow Title I, they have to have at least 15 employees. Okay. A lot of you may have heard that you have to have 15 or more employees. What you don't, maybe not realize is that only applies if you want to work for someone. Accessing a government agency, doesn't matter how many employees they have. They could have 1 person in this entire agency and the ADA would still apply. Title III, doesn't matter how many employees they have. The reason they put the 15 on Title I is they were afraid it was going to be a burden on small businesses in employment practices. So a company has to have at least 15 or more employees, and they have to have those 15 or more employees for 20 weeks out of the year. So you have a company that has 3 employees, but at Christmas time they have 40. There has to be at least 20 weeks during the year in order for it to count as 15 or more employees. I'm going to set that aside. That's all you really need to know right now. Oh, except for one more thing. It also does not apply to state agencies. It applies to city agencies and county agencies, but not state agencies, and that's a webinar in and of itself as to why that's true. All right. Okay. Title II is access to government services. Now, I'm going to talk about who qualifies, and it's good to talk about that here. Who qualifies for services as under the ADA? You have to be a person with a disability, and a person with a disability comes in 2 parts. You have to be a qualified person with a disability. Number 1, you have to be substantially limited in a major life activity. What's a major life activity? If you walk down the street and you yell, "Hey," and everyone turns around, except for 2 people, those 2 people are deaf. If most people can do it, it's considered a major life activity. If most people can brush their teeth without assistance, it's considered a major life activity. If most people can hear, it's considered a major life activity. Can see, it's considered a major life activity. The second part of that is qualified. If you go back to Title I, there was an actual complaint that I read one time of a person who was blind, and they were complaining because there was an application to be a bus driver, and the applications were not printed in Braille. That person, even if they filled out the application, would not qualify to be a bus driver because you cannot drive the bus, so you have to be qualified as a blind person. Here's where this steps in for me. I want to apply for benefits. I'm a deaf adult, let's say, and I want to apply for benefits through WIC, Women, Infant, and Children, and I want them to provide me an interpreter. I walk in and I say, I want an interpreter. They say no. If I tried to file a complaint under Title II, I wouldn't be qualified. I am substantially limited in a major life activity. I am deaf. But I am neither a woman, an infant, or a child. I don't qualify for any of the access to any of the benefits. But I have 3 children who are would qualify for those benefits. So I walk in as a deaf father of these 3 children and I say, I would like an interpreter. I don't qualify, they do, and I stand kind of in their shoes. So I would qualify because of my association with these children who do qualify, and I'm taking care of them. So there's things like that where you have to kind of step back and look at things. Under Title II, probably the most interesting thing that we could discuss is provision of interpreters, for access to government services. People ask me all the time, where in the law does it require a government agency or private business to provide an interpreter? It doesn't. Not in ADA, not in Section 504 of the Rehabilitation Act. There's no place where it says, in this instance, you must provide an interpreter. What it says is you must provide effective communication. But there are certain situations where you couldn't possibly consider communication effective without an interpreter. Traditionally, the Department of Health and Human Services and a couple of other agencies have said things like medical, financial, and legal. There's a presumption that if a person needs an interpreter, if this child going into the emergency room needs an interpreter and they request one, that effective communication probably can't happen without one. But there's an entire list of things. There's writing notes back and forth, there's using computer-aided, there's all kinds of things that could reach the idea of effective communication. So under Title II, it says any agency that's covered, meaning a government, a state, county, city, any of those covered entities must give primary consideration to whatever accommodation is requested by the protected person, by the deaf individual, by the person who. So if they say, I need an interpreter, the agency must provide that interpreter unless they can prove that the interpreter was not necessary for effective communication, and it is very difficult to prove a negative.
Okay.
Okay, you see what I'm saying?
Okay. They can't just come and say, well, I was willing to let them write notes back and forth with me. That wouldn't be sufficient.
It's not sufficient.
Okay.
If they request one, if they say, I would like an interpreter, then you must give primary consideration. If they don't, then it would be on the government entity. If there was a lawsuit or anything like that, it's their responsibility to prove an interpreter was not necessary.
Okay.
I tell you this as opposed to Title III. Title III applies to private businesses, not wanting to work for them, just wanting to access the movie theater or the doctor's office or the lawyer's office. In Title III, it says that the person who makes the final decision as far as what accommodation from this list is going to be provided is the service provider. So the doctor who, I look at this as an attorney and I say, the person who knows the least, about what is, they're not deaf themselves usually. There are a few deaf doctors, but if someone comes into the office and says, I need an interpreter, and they say, no, you don't, I don't know where they get information to counter that, but
okay.
They have the final decision, and it says they should discuss that with the qualified person with a disability. Not they must, not they have to, they just should. So if you look at the difference between Title II and Title III, you get an interesting difference, and that is under Title II, you go to the University Medical Center. They are a state agency. They must give primary consideration to whatever accommodation is requested. If you go to a private doctor or lawyer's office, it says they should ask you. It doesn't say they must ask you. They can just pretty much do whatever they want, so long as whatever accommodation they provide actually results in effective communication. And the problem with that is, of course, how do you know until after the fact?
Yeah, I think those are the biggest questions we get, is either like a family taking their child to a dentist or to a doctor, like we were requesting an interpreter, or there, you know, what is that if it's a private?
If it's private.
Yeah.
I will tell you something that it's really funny, because every time I bring this up, there's always somebody in the audience who goes, "Oh." The answer to that is in Obamacare.
Okay.
It's not even in the ADA. In the Affordable Care Act, there is a clause, and it only came into effect in 2016. It's called 1557, and it came into effect in 2016. And the clause, the fascinating part of this, affects Section 504. That's an entire webinar in and of itself, but Section 504 is another disability-related law that only applies if you accept federal money. If you accept federal funds, you have to follow 504. Doctors' offices accept federal money under Medicare and Medicaid. If they accept Medicare and Medicaid, and it's not if you have Medicare and Medicaid, it's if the doctor's office accepts it at all. Okay. If the dentist accepts it at all. Okay. If there's any funding that's coming through Health and Human Services, they have to follow 504. 504, I don't want to get confusing on this, is kind of the tofu of laws, meaning 504 and the ADA may cover the same thing. They may cover the same area. They may cover a private business that accepts federal money, or a government agency may accept federal money, or an employment where they accept federal money. They may cover the same entity, and they, in the law, neither one is allowed to give less protection than the other. Right. Okay, so why do I like 504? I like 504, and follow me on this one, because this is fun. 504, if it's being applied in the same general idea as Title III, meaning a lawyer's office, it acts the same way as Title III. Why would you want to use 504? Because in Title III, I have to prove that the business, the doctor's office, the lawyer's office, is the kind of business that the ADA applies to. There's a whole list. 504, I just have to prove they accept federal money, and we're done. So it's a little easier to qualify if there's federal money involved. Number two, almost all hospitals and doctor's offices around here accept Medicare and Medicaid. So they're all covered under 504. And then we take another step away from this. This is why attorneys get paid what they get paid. You take another step away from this to the Affordable Care Act, which says anytime 504 is being applied to any entity that accepts money through Health and Human Services, Medicare and Medicaid, instead of following Title III, should ask the deaf person, the person who's deaf, what accommodation they want. They have to follow Title II. Primary consideration, must give consideration. So it raises the standard up in medical appointments, at clinics, at hospitals, in doctor's visits, all of them, if they accept Medicare or Medicaid. And like I said, you don't have to qualify for Medicare or Medicaid. They accept Medicare and Medicaid from anybody. They have to follow 504, and under 504, the Affordable Care Act raises that standard. So even if it's a private doctor, and it would have to follow, the doctor's office would follow Title III, which says you should have a conversation about it. Okay. Now, because of the Affordable Care Act, 1557, you apply 504, it goes over the same area that Title I would apply to, but it raises the standard and says that office must give primary consideration to your request, and if they don't, then they have to prove why They have to prove a negative. They have to prove it wasn't necessary.
So when you, sorry to interrupt
No, go ahead.
So when you, because that happens so often, most,
Very often.
like you said, they most likely don't know.
Right.
So now we know,
Mm-hmm.
and what do we do when they tell us no? Like, how do we
If I got
work
a
through
nickel,
that?
if I got a nickel for every doctor's office that I've made a phone call to and said, you may want to consider this. Because the other problem that you run into is the doctor's offices immediately call their attorneys.
Right.
And I guarantee you, attorneys flip open the ADA and they read the requirements of Title I and they say, oh, your office doesn't have 15 employees, you're fine. That's not the title that applies. And so there's a whole lot of confusion. I spend a great deal of time teaching attorneys about this. And I will tell you this, if it happens, give me a call. I'm happy to make the phone call. I really am happy to make the phone call.
Cool.
If I have to write a letter or something like that, that's a different story.
Okay.
Right? But if I can make the phone call and say, you guys, here's the rules and you're leaving yourself, I make those phone calls literally on a daily basis. You know, a free coupon, I guess, for people who are watching the webinar. I'm opening myself up for, yeah.
I might have set a limit to that.
Yeah, I may have to do that at the end. How do you make a request for an accommodation? Here's another issue. Making the request for an accommodation is it can be a tool that you can use. I always say make requests in writing. Send an email, not a phone call, send an email. And in the email say, my child will need, or I will need a sign language interpreter. They have a history of using sign language as their primary means of communication, and any other written form of communication will not be effective because of the length of a doctor's appointment and the complexity of a doctor's appointment. You want to point out all of the reasons why an interpreter would be necessary for effective communication. You get a response back by a phone call and they said, well, we don't provide, and a lot of them say, we don't provide interpreters because we're a private doctor's office.
Yeah, or they just say, oh, we don't do that.
Oh, we don't do that. My answer, because I'm an attorney and I feel confident about it, is you actually do. Actually, you do. And you say, could you send me that denial? You're saying, we don't do that. Could you send me that in writing?
Okay.
And the minute you say, could you send me that in writing, people start to get very, very polite.
That's very
right?
true.
Can you send me that in writing? If they send it to you in writing, I will give you one more hint. Send back to them, and they say, we don't do that. Maybe they give you a reason, and maybe they don't. They say, we don't do that. Send back an email that says, can you tell me what evidence you would need in order for you to provide this interpreter? What could I explain to you? What could I tell you? What would you need to know in order to understand that effective communication will only happen through an interpreter? One of two things is going to happen. They're going to just say, okay, this person isn't giving up on this, and they're going to provide the interpreter, or they're going to say, we don't, or three things. They may provide you with the evidence you need, and you just send it back to them. That's fine. But what usually happens is they say, we don't do that ever for anyone. Under the Americans with Disabilities Act, they have to provide an accommodation if such an accommodation is requested. And they have to provide something that's on the list. So they think to themselves, we're just going to write notes back and forth. You say notes back and forth isn't effective. What do you need? What would I provide that would convince you, that probably the better way of saying it, that would convince you to provide an interpreter? And if they say, we will not provide an interpreter, that is a violation of the law because they have to consider every single factor. They have to, anything that's on the list has to be open for consideration. And if they say we will not consider something and it's on the list, that's a violation. That's when you call me and I give them a phone call and say, you understand, you've put this in writing. And if they don't put it in writing, if they don't, simply send them an email saying, this is what I understood our conversation to be. Please confirm that you agree with it or make any changes. You always want something in writing. It works so much better for you. Okay. Children specifically. Children are not, there's no real separation between children and adults. Anything that an adult would be covered by under the Americans with Disabilities Act, a child would as well. And
so there's no age limit?
There's no age limit on this. Sometimes, you look at this and say that the parent steps in their shoes and can make such requests for them. I'll give you an interesting one. For many, many years, and some of you are, I'm sure, aware of IDEA, the Individuals with Disabilities Education Act, which actually is now called IDEA, but nobody calls it that. Everyone just says IDEA. Only lawyers know that silly information. Under IDEA was considered, and Section 504 as well, by the way, were considered the exclusive remedies for anything that happens within the four walls of the school. So IDEA, if it has to do with education, IDEA is an education law. If it has to do with education, that was the law that applied in the classroom. If it had to do with access to the classroom itself, how do I get into the classroom? Not how do I get the knowledge from the book into my head, but how do I get into the classroom? That was Section 504. ADA there was this understanding that it never applied. It just never applied within the school. That changed 2 years ago. 2 years ago, there was a case that went in front of the Supreme Court called Fry v. Napoleon School Districts. And the issue was that there was a girl who had a service dog. And the service dog, once she was in the classroom sitting down, didn't particularly do anything for her. It would just sit under her desk. And so they said, there's nothing under IDEA that says we have to allow this service dog into the school because it doesn't do anything for her education-wise. As far as 504, they were iffy on that because it has to do with, as far as education, the dog wasn't doing anything to help her get her education. But if she left the classroom and had to travel to another classroom, the dog was supportive. I think she had cerebral palsy, but I'm not sure. Don't quote me on that. But she had a physical impairment that the dog helped her with her transportation in the hallways. So the school argued it has nothing to do with the actual process of education, therefore we don't have to worry about it. So they sued under the Americans with Disabilities Act. There were two things that the school argued back. Number one, you hadn't gone through the entire process, like going through due process hearing and things like that, and exhausted all the remedies under IDEA, so you can't sue us in federal court. And number two, ADA doesn't apply.
Okay.
It got to the Supreme Court, and the Supreme Court said, the school argued that it had nothing to do with education, that it had everything to do with what was happening outside of the classroom. Therefore, the biggest problem wasn't education, it was access. And therefore, you don't have to go through and exhaust all of the education, IDEA, due process remedies, because the issue wasn't about education, it was more about getting to and from the different classrooms, not the process of getting educated. So they said, she can sue. She doesn't have to go through all those. And by the way, there's nothing in the law that says the ADA doesn't apply here, that IDEA and 504 are the exclusive remedies. So up until about 2 years ago, it was presumed that the ADA didn't even apply within the four walls of the classroom of the school. Now it does. But to use it, you have to show that whatever the issue is, it isn't education. It isn't getting the knowledge from the books to the head. That's IDEA. It isn't access within the classroom. Like you can say, if you have a child who is deaf, and the school says, we're not going to provide an interpreter because they seem to be doing fine. They're getting B's. They're doing all of their homework. They're testing pretty well. But the argument there is, there are conversations that go on in the classroom. The students ask questions that I, as a deaf student, have a right to participate in those conversations. That's a civil rights issue. And so education is IDEA, civil rights issues as far as access are 504, and the ADA, we don't know exactly how far it extends. We really don't know, because then we have really this one case where they said, sure it does. We don't know exactly if it covers the same areas within the classroom, but we know that it applies to things happening outside the classroom in the school. What rights are covered by the ADA for children who are deaf and hard of hearing? The thing you need to understand is there's a very different standard for children who are deaf and hard of hearing than there is for a child who uses a wheelchair. What they have is, their standard is readily accessible. If you can make this place readily accessible, take down a barrier, build a ramp, and the ADA loves ramps.
I do love it.
They love wide doors. They love lower drinking fountains because it's one time, fix it, it's gone, and then you don't have to worry about it. The ADA has a harder time with interpreters because interpreters aren't a permanent solution. If I put in a ramp, the ramp's there tomorrow and anybody can use it. The ramp's there next week, next month, and anybody can use it. An interpreter is a very personal issue. And a lot of things like doctors and attorneys and they get kind of upset. They're fine with putting ramps in because that's access to a place. But think psychologically, I'm a doctor and you want me to pay for you to come and see me. That's not the way it works. You pay me for you to come and see me. Because an interpreter is an access to a person. I have to pay for you to access me as a person. The writers of the ADA realized that there was sort of a difference between physical and deaf and hard of hearing and sensory impairments. And so they said, it's not readily accessible, it's effective communication, but didn't really define what effective means.
Right.
And so it's really a squishy term as what is effective. And effective, they say, when taken as a whole, effective means you get the same access as a person who is not deaf or hard of hearing, which once again becomes a really squishy idea. Who knows exactly what?
So that's something
means.
you might want to have some help with if you have specific questions regarding access to language.
You would definitely want to talk to someone like me and say, okay, here's how we frame this, here's how we make this request. The problem is at the end, relief-wise, they separated at the beginning saying, this is the protections we're giving for physical disabilities, this is the protections we're giving for sensory disabilities, but in the end, the relief is the same. Under the ADA Title III, you cannot get monetary damages, meaning you can sue. As attorney, I go in and I represent you, I can get my attorney's fees paid. I can do that. But you cannot sue and say, we want you to pay us X amount of money. There is no relief monetary-wise. There is only injunctive relief, meaning the court will come and say, fix this, which works great with ramps because that's what they were thinking of. When they wrote, if you think about a person with a disability, the first thing that comes to most people's minds is a wheelchair because it's the symbol. And that was true when they were writing this law. They were all thinking to themselves, wheelchair access, wheelchair access, wheelchair access. Oh yeah, there's these people who are deaf. There's that too. Yeah, there's that too. And so they kind of applied it the same way in their thought process that they would for wheelchair access. I know a person with a, because I broke my leg, and so I know that mobility issues, or my aunt was in a wheelchair, and I remember it was really hard for her to get into places, and doors need to be wide. They think, if I was in a wheelchair, what would I want? Once again, they applied the same thing to people who are deaf. The problem is they have no framework under which to make any sort of assumption as to what a person who is deaf needs. So they went, if I was deaf, I wouldn't want to be deaf.
Right.
You know what I mean? And
that
so,
is very true, though.
And so they can't process the actual need. They just go, if I was deaf, I would write notes back. If I was deaf, I learned to read lips. If I was deaf, all of these things that are in the movies, true.
Right.
But in real life may or may not be. So I will tell you honestly, it is a much harder road working your way through the ADA for a sensory impairment, because this idea of injunctive relief, let's say that I go to the doctor, I'm a person who's deaf, I go to the doctor and I say, I need an interpreter, and the doctor says no. If I sue the doctor, I lose, because what I'm promised is effective communication, and we don't know if the communication was effective, would have been effective or not. Okay. So I actually have to go and fail to communicate, and then prove that I failed to communicate, and then I win, and what do I get? Another appointment with that doctor I just sued with an interpreter.
Right. Well, and as a parent, frequently, doctors just want us, the parents, they frequently are just asking, well, can you just interpret? So then if you're going and you're as the parent doing that role, then is that prohibitive of?
It's problematic. It's problematic for two reasons. It's problematic, one, legally in the state of Utah, you must be certified. You have to have certification. The ADA actually, in one of the regulations, says don't use family members to interpret because they have a vested interest in this. Do you want to be the one when the doctor says, your child Hampshire.
Right.
I don't want to be interpreting for that.
Right.
So there has to be licensure. You actually have to have a certification through either the state of Utah or the Registry of Interpreters for the Deaf. And I reach in my pocket and they look like this. I have them. So legally, under state law, no, you can't interpret, and they can't even ask you to interpret for that. Under federal law, there, like I said, in the regulations, it discourages it greatly unless it's an absolute emergency. But if a doctor comes back and says, can't you just do it? Say, I'm there as the parent. I have an emotional investment in this. I want somebody who's there, professional, from the outside, who can just do the work. You can also point out that there is a state law, and I don't know if you send out something or make it available.
Yeah.
I will give you guys the reference.
Okay,
the
cool.
State law that says if an interpreter is provided, they must be certified. The other part of that, really quickly, is if they say you have to bring your own interpreter, under the federal law, that is called it just dropped out of my head, a surcharge. You cannot charge a person. And my response to that, when they say, well, they can bring their own, I say, how many people who use wheelchairs have you asked to build their own ramp?
So that's your token phrase.
Yeah. That ramp out front, which wheelchair user did you ask to build that for you?
Does that apply for educational settings, or is that a whole nother beast?
Educational settings is a whole other beast.
Okay.
And when we get into educational settings, we're talking about IDEA.
Right.
Yeah. And I will tell you, I'm happy to come back to you on the WebinEAR, because that is an entire another animal all by itself.
Because that's another setting we get a lot of requests for, or like community programs. Like if the child wants to participate in a dance class, a swimming class, something like that.
These would be the kind of things that the ADA would apply to.
Okay.
If you think about it, because it's outside of the educational setting.
Right.
Or if it's a community program. Community programs are usually under Title II. Okay. They would be a government entity. It's run by the county.
Right.
Or something like that. Now, the county has a facility, and they bring a group in who's teaching a class there. They have a contract between the two of them. Both of them are equally responsible to provide accommodations.
Okay.
Usually, the facility, like the county rec center, is responsible for physical access, and anything that's more temporary would be through this contracted private entity. But you cannot get rid of your obligations by contracting with somebody else unless you absolutely you will be responsible for providing interpreters if they're requested into the contract. You can apportion it. But if there's no apportionment, the county would be responsible and the dance class would be responsible. And in that situation, interesting, because the county is working with them, it's possible to argue that the private entity that's providing the dance class has to follow the higher standard of Title II, because they are, you look at it, they're here, it's the county, it says county up front, everything about them says that they are the county.
Right.
And so they call it a nexus. There's this nexus between the two of them that says you are viewed as one entity, because I paid the check to the county for the dance class, I came to the county facility, and so the county says, well, they have to provide the interpreter, possibly, but they have to follow the higher standard, the primary consideration standard, not the just should talk about stuff.
Okay. Okay. And do they also have to follow the same rules of, like, an interpreter has to be certified or licensed as well? Like they can't just. The
only entity in the state of Utah that wouldn't have to follow that sort of licensure are religious organizations, churches, and that's a whole other webinar in itself. Is what is a church? Because churches run a whole lot of programs that you're looking at. That may or might actually be a church type of thing. And so for the state, religious entities and the federal government, like Hill Air Force Base and things like that, because the state can't burden the feds. They only have to follow the federal, but there is a federal law for employment that's called 501. Yes, there's a 501, there's a 502, there's a 503, there's a 504 that covers that, and Section 504 as well.
Okay. Okay. Cool. Cool. We're out of time. I feel like we just got started.
I was going to say, she said I have half an hour, and I said it takes me that long to clear my throat.
I know. Yeah. We definitely need to have a whole nother thing. I know.
There's no captions.
I know.
They won't happen.
Yes.
Yes.
Yes, we add.
They will add them later.
We do.
I will make sure they add them later.
They all. And then we will make sure that we have captions live if we have a request. Otherwise, they get added within a week. Okay. So sorry about that, but we're glad you're here. If you have any other questions about all of that amazing information, please let us know. You can private message us. You can comment on this feed. Dale is tagged on this feed, so you know how to contact him.
Please do.
Yeah, he's a really fabulous resource, and I can testify he really enjoys serving this community. So we have definitely benefited from him personally. So thank you for coming, Dale.
Thank you for the opportunity.
Have a great day, everyone. See you soon.